We have got information that they are going to take MPs to State House today in the night, and they are going to be given money, large sums of money, bribing people. But don't sell your conscience. They are going to take also the report of the parliamentary committee. This is another intelligence we have gathered. The parliamentary committee report is not supposed to be tabled outside parliament before it is tabled on the floor of parliament. Yeah. Now they are preparing to take that committee report to be discussed in NRM caucus in the presence of President Museveni in his State House Entebbe before it is tabled on the floor of parliament. That is also injuring further the parliamentary rules of procedure. The illegalities are adding on and on and on. So after the meeting has been done successfully, this is the FDC position. Number one, the UPDF Amendment Bill 2025. FDC considers the UPDF Amendment Bill 2025 as unconstitutional, and we reject that bill in its totality. Number two, without elaborating much into the details, we also look at the process, the procedure of handling the bill, even in its state of being unconstitutional. There are problems with the procedure, legislative procedure. The legislative process is wrong. A good legislative process has principles. One of the cardinal principles is public participation in the legislative process. We see the UPDF Amendment Bill 2025 falling short of that cardinal principle of public participation in the legislative process. The bill was introduced on the 13th of May, and it has not taken the minimum expected days, number of days, which would have given time for the public to participate. Now we are seeing it being rushed to the extent that we are seeing that tomorrow, which is the 20th, yes, the bill is expected to come to the floor of parliament and to be passed in less than 7 days just. The public has not participated. For example, where did you see members of the public in the forms of civil society organization participating in this? In the category of the academia participating in this? In the category of the ordinary citizens of Uganda in the constituencies? Even members of parliament have not had the time to go to the constituencies to present this issue to the people so that the people understand it. Why the rush? What is the trick behind there? And again, this bill alone affects so many people, even many institutions of government, including the police, Uganda police, the Uganda prison, and the prisoners themselves. Public participation would even need the involvement of parliamentary visits to the prisons to talk to the prisoners, particularly those who have been affected with the DC trial in the military court-martial. After the ruling of the court, which brought up this issue to parliament, how many people were transferred from the military court-martial to the civilian court system? How many, and what are their conditions? What is the status of their files? What are they saying about this? All this need consultation with the people. So the public is not consulted. What do we see here as people getting involved, like the Attorney General making a presentation, the Minister of Justice, and these are institutions of the government, institutions of the state. It is like internal consultation within the government itself. It has not yet gone out. So I would like to call upon my senior lawyer here, my colleague, my deputy president in charge of Central Region, Uganda here, Honorable Yusuf Simbambi, to elaborate more on the flaws, on the gaps, on the illegalities of DC UPDF Amendment Bill 2025.
The bill is unconstitutional. The Supreme Court did not decide that Parliament should make law, good law, out of a bad law. The decision had two key matters for us to consider as Ugandans. One, that it is unconstitutional to present and hear matters to do with the civilians in a military court, because military courts are disciplinary committees of the military. So that was the key decision. Then the other decision, which was also unconstitutional, that they have no competence and jurisdiction to handle matters of court, which are supposed to be in a civilian court, where you have officers like judges trained and with competence to handle such issues. The decision of Lord Justice Owin Dolo, the Chief Justice, about transferring files which are in a military court to a civilian court and be handled there, is what they call obiter. It is just a decision in passing. It is not the judicial finding. So Parliament cannot sit to make law out of a matter or a ruling or an observation in passing, as if that is the basis for us to make law, and overturn bad laws into good law. Then we're also having a problem that, having highlighted that we are considering a bill which is unconstitutional, we want now to overturn a decision of a court which in itself is unconstitutional. So we have two unconstitutional issues: making bad law into a good law, offending the Constitution, because that will be against the rule of law and the foundation of the Constitution, the rights of individuals who are suppressed and persecuted in a military court, because now you want to clean it. So now they will be citing provisions of an act of Parliament which makes law as if it is law, when the foundation of the law, what they call the spirit or constitutionality of law, is in rule of law. The spirit, the rule of law, it is not touched, you cannot see it, but it is the foundation of law. And then the rights of an individual as enshrined in the Constitution and in their individual constitutional universal rights. That is a scientific explanation. So no Parliament has jurisdiction under the Constitution, which constitutes Parliament, to make law, though you have legislative powers, just because you have powers. I'll give a quick example. You cannot make law that Ugandans should not speak. You cannot make law that Ugandans should not eat or visit bathrooms, because that's their universal and inherent rights. So now what we are doing, actually, we are making law where we have no powers to make such law, because the powers under the Constitution must be guided with the rule of law and the enshrined rights of individuals. So what is happening in a general court martial, it is against that. Now, no Parliament can make such a law. Then two, and also very important, which was really given to us, that these other observations cannot just be a basis. They are either administrative guidelines by those institutions. So you cannot now see to make law out of guidelines, because guidelines keep changing administratively. Again, that is scientific. And now we have a very big problem, and I thank the guidance of the working committee and our president, that at least now we are instructed, because for us now as members of Parliament, we are also not there. We are representatives of the people and our party. So our party has taken a decision.